You're mourning the loss of whomever has passed away, and you're mourning and you're frustrated with the process.
And common law means different things depending on what you're trying to do. Every piece of legislation has a different definition of common law. I actually had a fist fight in my boardroom once between three 60-ish-year-old women sisters over a property.
Someone dies, the house sits. The family, well, they're confused. And nobody seems to know what to do. I like to call it probate purgatory. Even when the process starts, it's a horrible process to go through. I mean, you're mourning the loss of whomever has passed away, and you're mourning and you're frustrated with the process. Is there any way for a family to avoid it or make it easier?
Well, so probate is required in real estate to move the real estate if somebody wasn't a joint tenant. So really the way to avoid it is to have whoever you intend to inherit the house on the property title. That's not always the best strategy. It kind of depends on the situation and where people live and all that good stuff. But if it's just straight up, like if I pass away and it's only in my name, which would be the case for my real estate, as it's just in my name, then the estate does have to be probated. Really, sadly, no way around that one.
So how about for myself? My parents live in Newfoundland. Should I be on title to their house?
Maybe, because I'm assuming you would be the sole beneficiary.
Yep.
So that really would make sense unless they were trying to do something like if they had a mortgage on there, the lender would have to consent, you would have to be on the mortgage, or if they were intending to finance or something in the future, then you would have to be part of that. We generally say to people that it's really situation specific because it can affect from a tax point of view, because now you are the owner of another property, so when you sell it, you've got different deemed disposition timelines there. Or if there's judgments against you or potentially judgments against you, you're in a litigious business, maybe they don't want to risk that. It's in Newfoundland, so maybe that's okay. Yeah. Nova Scotia, we have another little quirk because we've got that provincial transfer tax. So say my parents, if they wanted to add my sister and brother to their title, then we need to deal with that 10% transfer tax. So that's kind of...
You had to bring that up, didn't you? So
I hate it.
Just to go back, so I'm from Nova Scotia.
Mm-hmm.
And and I live in Ottawa. My parents live here. And my dad dies, and now the house is given to me. And if I go on title to that house, I pay 10%.
So if you're inheriting, it's okay. We can have a workaround for that. But if we try to prevent that from happening, so if we try to prevent probate by before him passing, adding you because you're a non-resident, then we've got to deal with the provincial transfer tax.
But sometimes that doesn't happen.
Yeah. So the problem is you either got to pay a tax here or you got to pay a tax there when somebody passes away when you've got the non-residents.
Now I just want to talk about the transfer tax. Thanks for that. So how long does probate last?
So there's, I think, 11 probate districts in Nova Scotia, so everywhere is a little bit different. So the initial approval of the grant in HRM, which is where we would do most of our probate, is right now about 3 months. Okay. Sometimes it's longer, sometimes it's shorter. It really depends on how many people died in that month, how busy they are, right? So, there's times when it can be 6 months. Once you get that grant, then the executor has the authority to deal with the property, or the personal representative has the authority to deal with the property, but they can't necessarily sell it. So again, it depends. So once probate's open, there's a 6-month advertising period where you have to put an ad in something called the Royal Gazette, which nobody reads other than lawyers, that says, hey, Danielle has died. If you have a claim against her estate, you've got to tell the executor or the administrator, here's their contact info. And then if nothing happens within those 6 months, then you can go ahead and you're assuming that you know all the debts that are there. until somebody gets something called a clearance certificate from CRA, so they have to file a final tax return and apply to get a clearance certificate. Clearance certificate is going to say, Danielle doesn't owe any income tax. That literally will be the day that I die. Yeah. Danielle owes no income tax anymore, so you can go ahead. So until you get that, in theory, the person that is the executor or the administrator of that estate, it can be held personally liable for any debts. So in your situation where everything is going to you anyway, with your parents,
yep.
Maybe you don't care about that. You probably know all your parents' stuff and you're going to be paying it out anyway. You might not be concerned about that. But say for me, if it was my parents and I would be running the estate, if I sold their home and then gave the proceeds to my sister and brother ahead of time, gave them each their third, if that was how it was set up, and then I get a bill from CRA for $200,000, well, guess who has to pay that? It's me.
Yep.
So it kind of depends on the circumstances, what we're going to do with that, if we want to go as soon as we get the grant or if we need to wait. Also, if you've got disputes within the estate or if you're just not sure what those debts are, then you're going to have to wait. Technically, you shouldn't even be listing something until you've got that grant of probate, because it's the grant of probate that says that you have the right to act and list that property and make decisions.
And that could be within a few months.
Be within a few months.
So, because I get this question asked all the time, can I still, sell my house, but the funds, let's say if the house sells within a month, the funds, they're kept in trust then until?
As long as you've got the grant of probate. So once you get the grant, if you're not sure about distributing the funds, a lot of times that's exactly what we'll recommend. We'll say, okay, we're going to keep the funds in trust until we have those clearance certificates, and then we'll distribute it.
But the buyer can still move into the home?
You can still close. As long as you've got that grant of probate,
yep.
The executor should, unless there's something in the will that says otherwise, or something in the grant that says otherwise, they should be able to sign off on the deed most times. So again, It's going to depend, because we got to stop, we got to look. Maybe the will says you can't do that. Maybe, you need certain consent, somebody's not willing to do it. But a lot of times you could at that stage sell it, and maybe you just don't want to distribute the funds because you don't know if there's going to be any debts.
Of course, and that would make sense. We talked about, I always say death and divorce bring out the worst in people. And I've seen it 16 years when I'm dealing with divorced couples, or I'm dealing with a family going through this, and emotions, greed. Would you see deals being stalled because of family disputes?
Absolutely. I actually had a fist fight in my boardroom once between three 60-ish-year-old women sisters over a property. So talk about not getting paid enough or something.
But that's not your fault at the point of the day.
Yeah, but so, and when you've got something that's in an estate and somebody's contacting you, like these are the questions that if I were a listing agent that I'd be asking. Are there going to be any issues with this? Of course, everybody's happy at the beginning. Then, you get listed and someone doesn't agree that they got enough, they think there's not enough money for it, or they think that their kid should have got it. And that's what comes up a lot is, everybody's super happy and then they list it and they get the offer, and then suddenly it's like, well, but little Johnny wanted to buy that and you didn't look at his offer, and then we go down kind of a rabbit hole with that.
So should someone in their will, when they're writing in the executor, if you have 4 brothers and sisters, everybody shouldn't be the chief.
Ideally, no. Unless you're really sure they get along, you really want to watch that. And that tends to be when we see the big disputes if they have 3 and 4 executors and they can't agree. So
what do you how do you bridge that gap?
You've got to go to court. If you can't agree, you're going to have to go to court to figure it out, and then all the money is gone into legal fees and all that other foolishness. Most times you can get people there, but when you're trying to do something in a quick turnaround, this is not the kind of deal to do it. So.
And it's so funny because very often when I'm in this situation, and even if there's only one executor, but there's like 3 or 4 other siblings, there's always someone who's like stirring the pot, poking the bear, wanting more money, not agreeing, making it difficult for for the executor. Like,
Now, a lot of wills will be drafted to say that the executor has the power to sell the property without getting consents. So really where we see a lot of these fights are when you do those foolish will kits and they don't have the right clauses, or when they die without a will. Because then sometimes people can't even agree on who should be the administrator of the estate. So if, I were to pass away and both my kids were adults, technically they're both entitled, as well as Wayne, my husband, to be executors or administrators of the estate. So if they can't even agree on that, then, where do you stand? Well, it's going to take a while. And it's interesting because sometimes we'll get deals come in with, Danielle signing as administrator of the estate of so-and-so, and there's no grant, and there's not even a will. So we don't even know if that person is going to be the one that's going to get appointed, because that's up to the probate court. So you really got to watch that stuff, really when people are contacting you for things going out of an estate, like your first stop should be, that's great, let's talk to your lawyer. And
I always do that because I don't want to get.
Can do.
You talked about joint tenants, but how about tenants in common? What's the difference?
So joint tenancy has a right of an automatic survivorship. So if you and I are joint tenants and I pass away, it's going to automatically go to you. So we don't have to do probate or anything. It just becomes completely yours. Tenants in common is different. So we see that a lot with like friends and business partners. So that means that you own your share and I own my share. So maybe you own 50% and I own 50%. So when I die, my 50% goes my estate, your 50% goes to yours. So we got to probate that because we don't know who, like the point of probate is you're proving what the last will is, or you're proving who the heirs of the estate are.
Okay.
So sometimes that can work great because if you and I go 50-50 on this house, I don't want it all to go to you if I pass away. I want my 50% to go to my kids.
Yep.
Tenants in common can be a good solution for that.
Okay.
But you get into the probate stuff. So we've been seeing more and more tenants in common because of the provincial transfer tax, because a lot of times we have people that need non-Nova Scotia tax-paying residents in order to qualify for mortgages. So you've got parents on title commonly with their children to help them qualify. We're trying to buy a condo. I have one of those right now. Right? So what we kind of do with that is you say, okay, well, we'll give you a 1% tenant in common interest, then you're still on the title. So for a lot of times, most lenders will approve it, depends on the lender, but it'll satisfy the lender because everybody's still on title, but they're not holding this huge piece, so they have less tax consequences and less provincial transfer tax because you're only paying the 10% transfer tax on the 1% interest instead of a 50% interest.
Yeah.
But of course, I keep saying, down the road, this is going to bite us all because we've got all these 1% interest holders. So people are going to start passing away and we're going to be probating like 1% interests in estates.
What would be the biggest myth that families believe that leads them stuck in probate?
The biggest thing that people think is that a common law spouse or spouse inherits everything. So especially with common law, because under our intestacy laws, like if you don't have a will, the intestacy laws in Nova Scotia for common law partners says that it's just a good friend. So we've had times where people have lived with somebody as a spouse for 20 years, had kids, raised families, all those typical things, but because they weren't legally married, when the title holding spouse passes away, they don't get anything at all. So
because if they're not divorced from the ex-wife from 12 years ago, she gets it.
Well, that did used to be a problem, but we've actually made a legislative change to that.
Okay, that's good.
Because for a while that was the case. It would be the spouse was entitled, or they'd willed something to their spouse, and easily 10 or 12 years ago now, we did change to say when you get divorced, it's any gifts to a spouse are revoked in your will, because we had some really big problems, and it was a case where that came up, that came up, where an ex-wife inherited everything.
I remember that, yeah.
Yeah, the common law thing is a huge misconception, and that's part of a discussion that people should be having with their lawyer, in particular if just one of them is on title and they're common law. And that's something that we bring up with people when they're in, if they say that to us, because they really, without a will, there's no automatic right to the property. You can go and you can argue, in court and say, well, it's not fair and equitably I should get some because I contributed this, and this. But, it's an argument that you have to make. It's not an automatic thing.
Because I'm going to be going through that, and the brother is the executor because his brother passed away, and he had a girlfriend who was living at the condo with him, so she's entitled to nothing.
Not unless there's a will giving her something, or she could try to go to court and make an equitable claim and say that she contributed whatever to it. But if it's just somebody that was just living there as a partner and they don't have a cohabitation agreement saying that she's entitled to something and they weren't legally married and they didn't opt in at Vital Statistics to say that they intended to be under that the Matrimonial Property Act legislation, then...
Because how often do you have in conversations, well, your common law is all the same difference. It's not the same difference when it comes to...
It's not the same thing. And common law means different things depending on what you're trying to do. Every piece of legislation has a different definition of common law. So that's a big, like we've had some really upset people when we've had those conversations.
I never knew that. See, I can learn. Old dogs like learn new things, right? Well, thank you once again.